its history and how it's developed over time, and why it's still relevant today. I should say that if anybody has any questions, I know Robin said we've got questions and answers at the end, but please feel free to chuck them out as you come up with them. I'm quite keen for this to be your session, and you get the information and the answers to the questions that you're really wanting to be answered. So that said, I'll give you a little bit about who I am. So as I said, to Robin, I've been working with the Law Society for 4 years. Before that, I was and still am a perpetual student. I spent 7 years at university, where I studied my undergraduate in history, a master's in early modern history, and then going on to do a law degree. I did want to go and do a PhD, but my mother, at the back there, to quote her, she said, "Get out and get a real job." So I did. I went and did a few bits and pieces here and there before gaining employment with the Law Society. So at the Law Society, I'm a policy advisor working within legal policy and law reform. So essentially my role is advising government and other stakeholders on the changes to the law, what changes should be made to the law, and how those changes to the law should be made. Initially, I was very much so all about the money. So I went and started my time with the Law Society in corporate commercial law. Very, very relevant to everyone. But soon after I started, our esteemed then leader David Cameron, announced that we will be holding a referendum on our membership to the EU. At which point I was summoned, having an interest in constitutional law and constitutional history. So that's a little bit about me. Excuse me, I'm parched. So when Robin called me up and said, "Gurdas, would you come and give a talk today at West Suffolk College?" It was sufficiently far enough in the future that I didn't worry about it. He asked for a working title, and I remember the conversation very well. I was driving on the A12 from Ipswich to London. Law, politics and the individual, thinking that's sufficiently broad enough that nearer the time I can work something out. And like all good students, I left it to the last minute. But that being said, when I actually sat down to put pen to paper, I thought actually it's quite a good topic to delve into. My belief is that all three of these, law, politics and the individual, are intrinsically linked, and none can work effectively without the other. As individuals, we have certain rights, human rights, civil liberties, and these rights stem from a moral agreement that we as a society make. And in order to give these rights force and to ensure that society follows them, in order to see how far those rights extend and what they mean in practice, we create laws by which we are governed. Now, as with everything in life, there are many different individuals, and their views on how these laws should be enforced and enacted vary greatly. And so we then form parties and groups and political parties that are based on our own beliefs and how we believe society should operate. And that really ties all three of them quite neatly together. I say that as though it's that simple, but generally speaking, on a theoretical level, that's how we work. Now, as a history student, I was always taught and always told to look and assess new ways in which we can see and view what's gone on before us. And by looking at laws and perhaps also more importantly the opposition to law, we can get a brief insight into how society was thinking at the time, what their outlook and objectives were. Now, with that insight, we can track over the centuries how a society's view has evolved and how a society has changed its way of thinking and being. Now, as society changes, we can see the mark of those changes in the laws that come about, the laws that are deemed irrelevant and no more fit for purpose, and we can see that actually that there are often periods of great social change that come before actual change to the law occurs. And I think the greatest examples of those are things like the suffragette movement and women's right to vote. In America, for example, the civil rights demonstration, the civil rights movement that led to greater equality. And even today, we look at things like our green initiatives and how we are, as a society, more conscious about the environment we live in and the world in which we live, and having more of a sustainable impact on how we live. Now this view tends to show that the law is constantly playing catch up to society. It's in some way a bit behind the pace. And this is true to a greater or lesser extent. However, when individuals sit down to draft legislation and to put into effect laws, and I certainly say this from my own experience, that the thing that's always at the forefront of the mind is how can what we are doing today be lasting? How can the change we make at the moment, how can that be given longevity? How can it remain fit for purpose in the years and the months and the generations to come? And that's always difficult to kind of counterbalance with each other and find that equilibrium. Today, in today's day and age, with the introduction of technology almost daily sometimes, we have, as a society, key conversations on how we moderate and regulate these technologies and how we ensure things like an individual's privacy is maintained. I mean, in recent times, we've had the Facebook and Cambridge Analytica scandals, where vast troves of data have been lost, and that again kicked up that question of, well, actually, what are we doing with our data? What are we doing with our own personal rights? How are these being maintained? Now, the key is always to make that balance between addressing sort of social change, but also ensuring longevity and flexibility within the law. Now, I say we are striking a balance and trying to create laws and create a society in which we are operating smoothly and ensuring that we are consistent in the changes we make over time. And when I was sitting down to write this talk today, I went to see a film a few weeks ago. I'm an avid cinema goer. There was a film about, it's called On the Basis of Sex. I don't know if anybody's seen it. It's about the rise of Ruth Bader Ginsburg. She's a US Supreme Court judge. And when she started, she had a lot of difficulty as a female lawyer working in a male-dominated world. She wasn't taken seriously. She ended up not practicing for a long time, and eventually she stuck by her principles and fought for women's rights and equality, and as time went on, I think it was Bill Clinton that appointed her to the US Supreme Court. Now, I mention this because there's a quote in the film. It's a misquote, but we give them artistic license, I suppose. It's from Ruth Ginsburg's professor, Professor Paul Freud. Now, he said quite eloquently, I think, what I'm trying to express now, and that is The court should never be influenced by the weather of the day, but will inevitably be influenced by the climate of the era. Now, I think that's key. I think that's key for anybody drafting legislation. I think that's key for the courts, and I think it's key for society, that we shouldn't be swayed by what's currently fashionable. We shouldn't be swayed by what the next big thing is, but we should evolve as society evolves. Now, this is where my interest in history kicks in, because in England, from the moment in 1215 that King John was subjected to and forced to seal Magna Carta, and I say seal because, as David Cameron announced at the 800th year anniversary, Magna Carta was signed. Well, he's an idiot, it wasn't signed, it was sealed. It's a royal declaration. I didn't tell him that at the time. At that point, in Magna Carta, existed a set of principles that, to this day, remain enshrined within our legal system and within society. It's formed the basis on which we have evolved into the current governing democracy that we are, and it's also influenced to a great extent other countries and other societies, as they have built their own constitutions in their own societies. I mean, I constantly look at America and think, oh, what a young country, what does it know about anything? It's not stayed long enough to influence and impact and understand how things have changed. But even they, when they signed the Declaration of Independence, used what was the essence of Magna Carta and the fundamental principles of who we are as people. Now, yes, it was more than just a peace treaty, and yes, soon after Magna Carta was signed, King John did a number on his barons and wrote to the Pope and said, no, I want you to annul this document. And the Pope did, and he called it the worst and most illegal stain on a king's sovereignty. And he said that it should be void and not considered valid forevermore. Kind of ironic that we're then still sitting here talking about it some 804 years later. But Barron's got a second chance, and in 1225 there was another great king who decided, no, I want to raise taxes. So the Barons stuck it to him again and said, right, we're going to keep you to this. And since then we've had principle that everyone is equal before the law, that the law must apply to everyone, that we have a right to a fair trial and a right to be treated equally and to be viewed equally, but also, and importantly, we have a right to access justice as we go through our society. And that, I think, is key, and that's what I want to kind of expand upon today. Now, I talk about Magna Carta as though it was the first and only time that these great ideas were put to a society. Well, it wasn't, but I think it was the first time it was actually really put on paper in terms of actually being a legal document. Now, Aristotle and Plato were talking about these very ideas. They were talking about a benevolent monarchy, yet one that respected established law and played by those rules. And that is the key part. Now, Plato said, it is proper that the law should govern that any one of its citizens upon the same principle. If it is advantageous to place the supreme power in some particular person, they should be appointed only guardians and servants of the law. Now, Aristotle went on and said, we are all servants of the law if we are to be free. Now, this is all very well and good. They're talking about principles of what we now see as democracy. But they weren't. They at the time were still very much in a sense of, no, we have a supreme leader that is appointed by God, and that is God's divine representative on earth. But it's that code, it's that argument, that sense of morality that we've brought forward through time. And whilst Plato, Aristotle, and even Cicero, who believed that we have these divine appointed rulers, they still had at that time a sense that the law should be enforced and everyone should be equal before that law. Now, the significance of Magna Carta, I believe, shouldn't be overstated. Many lawyers and historians believe that document was essentially the founding stone of our constitution. Some have argued that it's the first time in which a sense of democracy could be seen to be emerging. And I disagree with that. I think there were too many other things going on socially and within the era that I think it's a stretch to say that this is really the founding moment that democracy really started as an idea. I don't think that's the case. After all, these rights and liberties were enforced by barons and nobles, and they were a part of the ruling class and very much apart from the everyday man. So whilst I don't think we can go as far as to say that it's the forefront of the birth of a democracy, it's certainly the point in which we can see our own constitution forming. Now, during the civil wars, Magna Carta was again used to restrain the power of the king. I wrote my dissertation in my master's on the shifting balance of power from the divine right monarch to and towards a parliament that was elected from a small group within society, but nonetheless elected. And this shift across can also be seen at different areas and different times of society, definitely in different countries. The founding fathers used Magna Carta as their basis on which all rights could be gained. I mean, and the American Declaration of Independence talks of life, liberty, and the pursuit of happiness. Now, those elements come from Magna Carta. They come from this belief in the rule of law, that we as individuals have a set of laws that everyone, without fail, is equal before. Those are our liberties. Those are our rights. Now, in the 19th century, skipping forward a few hundred years, along comes a guy called Dicey. Dicey was a constitutional lawyer and scholar, and he wrote something called the Great Constitution. And in that he wrote that there are two pillars of the British Constitution. One is the rule of law, and the other one is parliamentary sovereignty. Parliament is the supreme place where laws can be written. There is no higher authority in this land than Parliament. Now, we can see that the rule of law has had a profound impact at different stages and throughout history. And as I said at the beginning, it allows us to give or have a brief glimpse and insight into the minds of those at the time of great social change. Now, it is just a glimpse, because there are. I'm a historian that prefers sort of high politics and traditional history, but my colleagues and friends that are more into their anthropology and their social change will tell you that there are many factors that influence the changes that we see throughout time. Taxation, the way people are treated, the Industrial Revolution, all of these things have undoubtedly a profound impact on these times as well. But I believe that at the centre of this change, there had to be a core set of principles that we as a society agreed to and enforced. And that is the rule of law. Now, the question we then must ask is how, in a modern society, with all the history behind us of the rule of law, does this become relevant? What role does it play within a modern society? And what impact does it have on us as individuals? Now, we can see the principles of the rule of law throughout each branch of government. The government itself, the executive, Parliament, which is supreme, and our judiciary. All three branches show that this rule of law, the principle that we are all equal before the law, that we all have a right to justice. Now, whilst Parliament is sovereign, that doesn't mean it's not held accountable. That I think is a key part. Parliament is sovereign. It is the highest place in our land that can make laws and determine the way in which we act. The way in which we act as a society. However, it is still accountable. It's accountable to us as individuals, us as a people. And we directly influence that by the way in which we petition our parliamentarians, our MPs, but also, crucially, how we vote. As a society, the biggest occasion that we have every 5 years with the Fixed Term Parliaments Act is when we go to that ballot box. And that's why I strongly believe that everybody should go out and vote. Even if you go and connect through the whole thing and go, no, you're all bloody useless and I don't like you whatsoever. Fine, do it, say it. That's the point in which we hold our leaders accountable. And it's exactly the same with the judiciary. It is exactly the same with the judiciary, and it is exactly the same with the executive. All are held accountable before the law. No matter who you are, no matter what you do. There are many judges throughout the land that will tell you, my courtroom is my domain. And that is true. That is true. Any time a judge sits in wig and gown on the bench, he or she has the opportunity to uphold that which has come before us, those precedents, or change. And that's dictated to by the case or the set of circumstances that he sees or she sees before them. Now, the rule of law is more entangled in society than just the basis for our government. It's the yardstick that we measure both our own morality but also foreign governments. We use how they interact and how they show the rule of law as a determining factor in our interactions with them. Banks will look, and the World Bank within the International Monetary Fund will look at the rule of law and how they preach and practice those principles as a yardstick of how much we will interact with them, how much we will trade with them, and I think for our country, crucially, how much aid we will give them. Now, these are modern day examples of how we are viewing the rule of law. It's come to the point where we see it as so profound, as so ingrained, and such a fundamental principle that we are using it to determine our interactions with our allies, with our neighbours, and with our enemies. And I don't think that as a principle then can be understated too much. The rule of law has also played a very key part in forming organisations like the United Nations, the European Commission, and the European Union. The European Union was born out of a sense after the Second World War that we must come together as a society so that what had gone on would never happen again. And in that was then the ethos and the determination to make sure that we don't just have equality, but we actually have those founding principles. We have those beliefs and those virtues operating within our society. Now, you can see the changes that have come. The Declaration of Human Rights, which directly references in its opening paragraphs the rule of law, and it says that actually our fundamental right, our fundamental liberty is this equality. I keep going on about it, this equality before the law, but also our ability to access justice. And that is the most important thing I think at this stage in our society, the access to justice that we as individuals have, and the access to justice that we have comparatively to each other. The High Court held recently that the government's reforms, I'm calling reforms, to things like legal aid and our court system, it held that those changes were directly in contravention of the rule of law. It held that they limited access to justice for people that couldn't afford it. It limited access to justice for those that weren't in a position socially to engage with the justice system, people that were of a poorer socio-economic background, those that perhaps weren't as well versed with computers. The movement from physical courts to an online court system, again, whilst it sounds great, yes, we can save lots and lots of money because we don't have to have these big archaic buildings to heat and put people in, and actually we can do lots of these things online. And it's true, there are lots of things that the traditional court lacks in terms of technology, but the fundamental thing that you remove when you move to a court that's online is people's access to it. Now, as a young person, I'm very, very aware of how I can interact with technology and how I can determine and use technology in my everyday life. And I say this sitting 10 feet from my mother. Mum struggles to operate a microwave at times, let alone a phone and a computer to access a court. So automatically we are segregating a section of society from accessing justice purely because we've moved it online. And that's what the Supreme Court held. It held that this is unconstitutional. It is in direct violation of the rule of law. Now, that is today still our fundamental principle. We are still, 804 years later from Magna Carta, looking at how we operate as a society and how we still stick to those virtues within the rule of law. So, as you've gathered, all things related to the development of constitutions and the development of legal history, it excites me. I like it, I find it intriguing, and I love spending hours and hours and days poring over archaic texts that might give me some glimpse into how this is evolved. Now, I appreciate it's perhaps not as exciting, and that's why my wife is up the back today, because if I got too boring, she'd threaten to chuck stuff at me. But I do. I find it incredibly fascinating. Now, at law school, and whilst I was studying history, I had friends that constantly said to me, "Come on, Gurdas, it's really not cool. It's really not great. What on earth do you need to learn constitutional law in the depth that you're going into it for? All the great things, all the massive social changes have already happened. We are still, admittedly, still fighting for equality within places like the workplace. We're still fighting for equality for people with disabilities and the way in which we're treated. But those fundamental bits, those fundamental earth-moving events have already happened. Why do you want to keep studying constitutional law? It's boring, it's dull, it's a lot of reading." And then along came Brexit. And that was my chance to laugh in the faces of my colleagues, of my classmates, because all of a sudden I was in demand. There were very, very few of us that could say that we had insight into the Constitution. And actually, Robin said that I've been fortunate enough to. I was going to say rub shoulders with the ISIS. I'm not sure that's true. To rub shoulders with those that govern us, let's put it that way. And he's right, but as I said at the beginning, my initial brief, the job that I applied for when I joined the Law Society was in corporate and commercial law. But when David Cameron announced the Brexit referendum, the Law Society, the government looked to the Law Society and said, right, can you send us somebody that has some experience and has expertise within constitutional law so that we can ensure that the way we run this referendum, the way the referendum is put to the people is just and fair and within the bounds. And the Law Society scanned and scanned for people and didn't have anyone. And so my manager came to me and said, Gurdas, you did your master's dissertation, but surprised me that you read it, because currently the only 3 people that have read it was me, my dad and my professor. But he somehow got a copy and said, right, you seem to know what you're talking about in terms of constitutional law or constitutional history. Off you go to Downing Street, see what you can do for them. And I've kind of just stuck around. It's not been a case that I've been brought into a specific role. It's just that it's very difficult to get rid of me once I'm there. But my parents told me, do whatever it is you're interested in. So I stuck to it. And as I say, suddenly all these questions began to surface about how do we run this referendum? How do we ensure that it's fair to both sides, Leave and Remain? How do we ensure that the referendum is equally balanced? It's balanced by the question that we put to the people, but it's also balanced in the way we run the referendum. Now, given that we'd spent the last 40 years as members of the European Union, the Leave campaign, quite rightly, thought that there would be an unfair advantage given to the Remain campaign, given that the government was backing it. So again, how do we ensure that we as a society have a referendum, have a chance to poll the people in a fair way? And that's why we have things like the Electoral Commission, again, holding government accountable. They are ones that sit down and tell you, no, you can't have this question, that's too much weighted one side or the other. And a bit of information, before we had the final iteration of that question of do you wish to remain a member of the European Union, we had some 25, 30 different iterations of that one question. Now, as we know, the referendum was debated by both sides, and one of the key aspects of the referendum, immigration played a large part, but one of the big questions and talking points was sovereignty. We want to remain and retain our sovereignty. Us as Great Britain, United Kingdom, we want to keep our sovereignty. We want to take back our control. Now, those were the words that we used. Now, regardless of whether I agree or disagree with the arguments that came before us, we had to look at this. We had to think, what does it mean for us as lawyers, for us as individuals? What does it mean to us to keep that sovereignty within Parliament? And it's a question that we're still currently debating and arguing, and I don't think it's a question that's going to go away anytime soon. Because as we, as a society, evolve, as we as a society move in one direction or another, that has an impact with how we interact with the law and how the law is then enacted and imposed on us as individuals. Now, in the last 2 years, since the referendum, in my view, we have had more so-called constitutional crises than perhaps we've had in the last 50 years. The biggest of the biggest came very, very soon after the referendum, with the Supreme Court ruling on whether Parliament should have a vote on Article 50, or enacting Article 50. And whilst in the media it was largely played out as this battle between Remainers and parliamentarians not wanting to respect the vote, actually deeper than that was this question about sovereignty, about the rule of law. That was the fundamental principle that lay at the heart of the question. Should Parliament be given a vote to enact Article 50? And ultimately, as we know, the Supreme Court ruled that yes, Parliament should be given a vote, that Parliament must be given a vote. And that was done. That decision was come to after 800 years of precedent. And that precedent began, as I said at the beginning, with the signing of Magna Carta. The Supreme Court, in their, I think it was something like 207-page deliberations and reasonings why they reached the decision, they quoted both Magna Carta, the Bill of Rights, and every bit of constitutional law that have built up over the years that form the precedent that we have now as a society, that we are equal before the law and our government is accountable. Now, the vote said that even though we held a referendum that showed the will of the people, parliamentarians and MPs, as representatives, elected representatives of society, must be given a vote on the matter. In more recent weeks, we've seen a unique set of circumstances where a government loses votes, a government maintains confidence of the House, and only a few days ago, we had the news that John Bercow had announced that there cannot be another third vote on the government's deal, on Theresa May's deal, and the essence of that, the basis of that decision by the Speaker, was founded in law that dates back to the 16th century, 17th century, and whilst the media again portrays it as politicking, the to and fro struggle between remain and leave, again, at the heart of that, just as it was with the Supreme Court decision, at the heart of it was this sense, again, that the rule of law must come first. The parliamentary sovereignty must be respected. And that I think is the key point, because you can't just keep putting the question. What was it Albert Einstein said? Stupidity is asking the same question again and again and expecting a different result. Now, that's exactly what Parliament has said. We have made our will known. We have said that we do not want this version of the deal that you have negotiated, and you can't keep going back to Parliament and hoping beyond hope that they're going to get bored and just change their minds because it's easy. But, politics aside, that principle lies at the heart of it, that the responsibility and the decision of Parliament must be respected. Now, some say that these are archaic rules and that Parliament can't continue to rely on decisions made back in the 1600s. Well, yes and no. I go back to that quote by Ruth Bader Ginsburg's professor, that the courts must move with the climate of the era. But it's important to look back at where we've come from and look back at the precedents that we've been served. Because in a constitution that has spanned 800 years, there are very few things, in fact, that we haven't dealt with. There are very few occasions or instances that we haven't come across before. Now, what does that give us by looking at those precedents? It gives us a sense of stability, it gives us a sense of solidarity, but more importantly, it justifies how we act. Now, of course, society can determine that we are going to change our views on a set subject, and that's perfectly within the rights of Parliament, and that is, again, the essence of parliamentary sovereignty. But only by looking back, in my view, can we understand the past, can we understand where we've come from, and can we understand where we want to go. And as I say, having 800 years of history behind you, the pitfalls that come with certain decisions inevitably get exposed, and it's learning from those mistakes, it's learning from those examples that I think gives our constitution, that gives our country the strongest foundation. Across the world today, even when we have other countries wanting to enact laws and do trade deals with one another, they still look to the UK as the greatest source of legal stability. China, who are currently building what's going to be a multi-trillion-dollar project it's called the Belt and Road Initiative. They're going to essentially build a long road from China directly into Europe. Great, you say. But again, they look to the UK to form their contracts. They look to the UK as a legal place of certainty. And the reason they do that is because we have that stability. We have that ability to look back and learn from how things come before us. Now, I believe the Brexit process, whichever way you look at it, has highlighted how our constitution still affects and influences the decisions that we make and the decisions that government makes around us. From a personal perspective, I think it is a testament to how strong our constitution is, but it also shows how society plays a part in the ever-changing and evolving role of the law. It is, I think, one of the strongest examples of how the principles of our society and the morals by which we want to live by are kept true and are kept strong and are kept in some sense, they're kept within a bound that we can say with certainty, this is how we want to proceed. Now, again, whichever side of the argument within Brexit you fall upon, the fundamental elements are still there. We as individuals have a right to express our views. We have a right to freedoms. We have a right to access our courts and our justice system. Everybody within the process is accountable and must be held accountable. But also, and I think this is the greatest point, that we as a society have the ability to dictate and push the direction of our own future. And the way in which we do that in a sustainable manner, I believe, is through the law. So, with that in mind, do you have any questions about anything I've said, anything I've gone through? I know it seems to be talking a great deal, I was conscious about that, but anything about the Brexit process and how we go? Yeah.
I'm just focusing on what you said about the master's degree. Do you think that the separation of church and state and the erosion of the clerical legal system versus the secular was actually the rise of both individuals being able to really take on laws that they found unjust? Or do you think it was replacing one system with another?
That's a brilliant question. Personally, I think it allowed us to go down a certain path, and it's difficult to view history as a kind of what-if scenario, but the importance of the church in the government of the state has always been its moral compass, I think. Now, regardless of what system you ascribe to, there is always this there's always this danger that one party is going to have more influence over our direction than another. And I think in our history and in centuries past, the church has played that dominant role in deciding the way we work, deciding the way we interact with each other, and deciding the way forward of a country. I mean, even today that can be seen with Sunday trading hours. The whole idea of Sunday trading was that people can go and worship. In terms of trading it off with on a different journey, I think it's definitely been a strength of our democracy as it's evolved and our law. But I don't think, and I say this as somebody who is obviously religious, I don't think you necessarily need religion to have morals. That's I think been clear since year dot. That's not the point. You don't need religion to say you have a moral compass. As with anything in law, religion has always been the peg on which we justify what we do. And as any historian will tell you, as any lawyer will tell you, your point is irrelevant if you can't back it up. And I think in years gone by, religion was that backing. It was that real background on which we were able to say, yes, this is why we're doing what we do. And I think as time's evolved, and definitely in the modern era, religion doesn't play that part as it once did. I think society has its own view and its own moral compass in and of itself. But I guess in answer to your question, yeah, I think it was a strength that we separated our belief. Not great for Charles at the time, but that being said, no, I do think it is a...
It's not wonderful for Edmunds first, either.
No. Does anybody else have any?
It intrigues me, John Bercow, and going back to the regulation or law from the 17th century.
Mm-hmm.
Are there people in government who would have knowledge of that, or is it something you would say, is there something in archives that we can use?
There are people that have knowledge of that, and there are people that go and research them. I'm among them. I get presented with a problem and I go away and go, right, where can I look as to how we can answer this question. In practice, the way it works is Parliament is very good at recording and storing everything that has been. It's one of the reasons why even in the digital era, every law that is passed is still inscribed on vellum, because the worry is that if the millennium bug ends up hitting at whatever point and erases all of our technology, erases all of our data and records, but then we still have a hard copy of what's been said. But yeah, there would be, he will have a whole office behind him that will be looking at issues as they come. There will be a group of people that are what we call in law as horizon scanning. What's going to happen and how can we mitigate whatever is going to happen. One of my biggest responsibilities is actually looking at all of the different options and all of the different permutations of whatever may happen, and that takes up the majority of my time, if I'm honest. A lot of it doesn't get used because we follow a certain path and the rest of it then becomes irrelevant. But there are people that are responsible for foreseeing these questions and foreseeing these issues and then dealing with them in a way that it can be then expedited quickly. I think that was another question. Yes?
I just want to ask you are you sure you're not placing too much regard on history? Because as you said, one thing you said was society evolves. Mm-hmm. And whilst in the second millennium of the Common Era, yes, the law and politics might have been appropriate, and parliamentary sovereignty and the individual's access to the law might have been appropriate. Increasingly today, the economy is a global economy.
Yep. Society is shaped by a World Wide Web, mm-hmm.
and the individual doesn't have sufficient access to the law to seek accountability from transnational organisations, from international politicians and international crime, and corporations cannot be held to account. We see that every day. That is the way society has evolved and appears to be evolving in the future. So is the law and politics, which are founded on the nation state usually, and the individual as a citizen within a nation state, going to continue to be appropriate for the third millennium?
I think one of the first things I would ask in response to that is that lack of accountability a problem with the law or a problem with the implementation of the law? And my experience would probably be it's the latter. Now, I think, and you're absolutely right, that this is where this sense of evolving, an evolving nation and evolving society comes into it. But yes, there is always a danger that we are placing too much emphasis on what's come before us, and that we are abiding too much by things that have gone on in the past. But I think the key element, whenever you look back at history, is to see what is relevant. What is it that we can learn and we can glean in order to see how we want to progress. And I think the biggest area that the law does that and looks back to the past and to its history is our response to how we manage data. Now, I'm not saying for a single moment that we're there. I'm not saying for a single moment that we actually have the answers, but having a basis of our rights and freedoms and responsibilities as well, that's also a key, I think forms a fundamental part in how we deal with these problems. I think actually our background and our history forms a very relevant aspect when we deal and tackle these issues. You're right, absolutely, that we live in a globalised economy and we interact with actors and people that have a different culture to ours and a different understanding of what's important and place different values ahead of values that we may put at the forefront. But I think that's the key, and that's the element that makes us as an individual state actually shine out. And yes, we have a tendency to look back too much, I think sometimes of the past, and stick by it too rigidly. But I think ultimately, in order to change, we must change in a sustainable way. And whether it goes from a society at university to a large corporation or a government, none of them make changes sporadically. They don't do it on a whim, and they do it by looking back at how things are done and doing it in a measured process. And I think the strength of doing that means, as I said right at the beginning, that we have the ability to continue to evolve and have the ability to look at things in a broader perspective over time. So, yeah, there is always the danger of placing too much emphasis on it, but I am of the view that actually it gives us more information and gives us a stability that we can move forward with.
In a similar vein, back in days of the Dutch East India Company and the British East India Company, as transnational organisations which were immensely corrupt, the response of government was to shatter them, to bring it back to the nation state by destroying the transnationals. Whether that is remotely feasible with today's transnationals, I don't know.
I would like to comment perspective. We live in an era where we are becoming more aware, and the gentleman mentioned that that we have a World Wide Web and we have this basis of information out there. And I think actually one of the strengths of that is that for those that are interested and for those that do want it, it is accessible to them. I mean, I don't think it's a coincidence that with the in the years of the expansion of the internet, we've seen a rise in litigants in person in court. I think that's a direct consequence of actually people being able to access the law more freely, being able to read about how things work, and it not being kept within an elite of lawyers that we deal with this, you're not going to understand it. And I think that's probably the largest reason, the greatest reason why we have seen a rise in litigants in person in court, because we have that access, we have the information available and the ability to understand and act on it.
I think we have time for one short question.
You mentioned from the quote by the professor about how events are shaped by the climate of the era. So I wanted to sort of ask around Brexit and the fact that many people seem very fed up that the adversarial nature of British politics and the fact that it's a first past the post, so one party almost dictates the agenda. There's an appetite that isn't an effective form of government for getting through very politicised issues like Brexit. We're too split for one side to dictate. So I wondered what you felt the climate of today's current era is and how that's going to sort of influence how our democracy goes forward from that, if we're going to become more.
It's an interesting question, and I think my answer is very much time. I think I think perhaps the younger generation, there is a move within that demographic to have a more equitable form of government and a form that we choose our government. I mean, I personally, when the coalition government was formed between the Liberals and the Conservatives, there was a referendum on whether we should change from first past the post. In my view, unfortunately, the proposition that was put forward was alternative voting, rather than something having a majority of on the basis of how many votes a party has got in Parliament. I think our Parliament itself and our government restricts perhaps how we will change. I think, given that we have the nature of two houses within Parliament, it would mean, on a practical level, us disbanding that particular model, perhaps, and have one that's more akin to, say, a Senate that they have in Australia or something like that, to make our Parliament more in line with those sorts of views. I think the younger demographic, there is definitely perhaps a feel for that change, but at the moment we have the largest portion of our society actually is an ageing population. Whether that appetite continues, whether it changes in the future, I'm not sure. I think with the access of information that we have, ultimately there is going to be a system by which we hold our government more easily to account. I think that's being shown even in this Brexit process that we're going through. There is a format and there is a platform for people on both sides of the argument to really question why our parliamentarians are doing what they're doing, and also a platform for them to be heard. I don't think if this was an issue that would have happened 50 or 60 years ago, we'd have the ability to make that. I don't think our society would have the impetus to be able to do that. Yes, I think it is changing. Yes, I think it will change. But I also think that for change to be sustainable, it should be measured. And I think that is ultimately the key in how we progress as a nation.
Thank you. Good question, Jonathan.